This is the American Law Journal.
Social Security disability claims are backed up to nearly 1 million. At the same time, judges are approving less cases and claimants are feeling the squeeze. Good evening, I'm Christopher Naughton. Welcome to ALJ. The biggest backlog in the U.S. government today are Social Security disability cases. What does that mean to the future of the system? What does that mean to those of you who are desperate for help? David Farenthold with the Washington Post explains.
Imagine a waiting list that is 990,000 names long. That's more than the population of 6 different U.S. states. Today, that's the number of people who are stuck waiting for a decision from the Social Security Administration's Office of Disability Appeals. It's one of the longest backlogs anywhere in the federal bureaucracy. More than the patent applications now pending at the Patent and Trademark Office. More than the veterans waiting for an answer from the VA. And the one at Social Security is still getting bigger all the time. So how in the world do you keep 990,000 people waiting at once?
Well, at Social Security, the answer is a little parable about how government's best intentions sometimes go awry. In this case, the good intention was to take an old American ideal that every individual deserves due process before the law and apply it to the vast caseloads of the new American welfare state. The only problem is that well-intended system has never kept up with the demand.
Here's how it works. Every year, hundreds of thousands of people apply for disability benefits, and no more than 40% get through. If they appeal, they eventually see one of 1,400 special Social Security judges. The judge's task is a big one, to determine if this person is too disabled to hold a job. Judges must read hundreds of pages of medical evidence, and some of it is in doctor's chicken scratch. Then there's a hearing where a judge must act as a kind of human lie detector, trying to gauge if the applicant is telling the truth about some invisible malady like chronic pain or depression.
Once a judge has determined how disabled an applicant is, they must then search the U.S. economy to see if there are any jobs this person could still hold. To do that, they use an official guidebook, the Dictionary of Occupational Titles. The problem is this book hasn't been revised since 1991. So it still includes jobs like telegram messenger and horse and wagon driver, which is sandwiched between horizontal stick turning machine operator and horse race starter. In this book, the only listing for web worker is for a job repairing fishing nets. The word internet does not appear in the book once. Because the listing is faulty, the judges must do extra research and call in expert witnesses to figure out if the applicants could actually hold a modern-day job. Finally, the judge must write or help write a multi-page legal decision.
In recent years, Social Security pressured judges to decide cases more quickly. The backlog did go down, but some judges sped through cases by simply saying yes and yes and yes. A number of judges said yes in more than 90% of cases. And remember, these are cases that have already been rejected at least once.
Today, Social Security has changed tactics. It's limited judges' caseloads and encouraged them to take a little bit more time. But the result is they keep falling further and further behind. And this enormous backlog keeps getting bigger and bigger.
1 million case backlog. We'll weigh into that tonight, taking your telephone calls as well. 1-800-426-4625, the number right here in the studio. We'll be joined by a judge by way of on the line from Texas in just a few minutes. But let me get to my guest right here on the set tonight. Jess Leventhal joins us once again from Leventhal, Sutton, and Gornstein. Jess, in the practice of law, let's just say for several decades now, all of it in the area of Social Security disability, right from
Absolutely.
the get-go,
yes.
from day one. You're a claimant's attorney, right? You started out that way, right?
Yes.
You didn't
Not
start
like
your own
that one.
practice early on, though, did you?
Yes, I did.
You did?
Oh,
Did you
yeah.
come out of law school and put your shingle out?
I came out of law school and actually worked for a year for someone else.
Okay, all right. Back in the day when
that
you could
was
put a
so
shingle out,
entertaining.
after two or 3 years, you could put your shingle out. Also with us this evening, as he has been for almost 20 years now, I have to go back to the old videotapes. I think we have a turntable here at the station. We could probably play them on. Alan Polonsky.
I had hair in those ones.
Did you? I think, yeah. Well, at least it was darker what you had, Alan. Alan Polonsky hails from Polonsky and Polonsky in Audubon, New Jersey. And as I like to say, Alan did actually start his career working with the Social Security Administration, handling disability claims, right?
Writing
Back
the
in those
decisions
days.
for the judges.
Right, okay. So you got to, not unlike prosecution, not unlike civil litigation, sometimes you learn what the other side, if you will, is doing, and then you change hats and then you prosper.
We call it the good side of the force.
I'm
yes.
sure you have. I know you've worn the white hat many times. Let's take a look at this backlog again. In some ways in the last year, what we've really tackled on this program is delays in Social Security disability, the argument on the left and the right, whether too many people are receiving benefits, the breakdown of the system. All I keep hearing is breakdown, breakdown, breakdown. And we look at some of the statistics. So we're up to 990,000 people waiting. That's insufferable. That's
incredible.
unconscionable, and yet it goes on and on. You guys are going to probably tell me, well, they're not giving us enough money. That's not what your adversaries would say, but that's probably where you're going to start, right?
I'm not so sure that they wouldn't say the same thing. I was listening on the way up here today. There was a discussion with the new Veterans Administration Secretary, and he was talking about the delays in the Veterans Administration. And he said, we need more resources. Well, they need more resources everywhere. They need more resources for the Veterans Administration. They need more resources for the Social
But have they
Security
been cut?
Administration.
Here's the question: have they been cut back, or has the program expanded so much that we need more? We need
They've
more
been
money.
cut back. There's 10% less, 10 to 15% less employees in the Social Security Administration than were there 5 years ago. They've hollowed out the process. They've gotten rid of the clerical help. They have professional people doing clerical help because they don't have clerical help. At every step in the process, there are less people, less bodies, less people available to do the job. And this is what the result is.
And again, Obama's been trying to cut back this deficit now going on 6 years. This might be one of the casualties, Jess.
It is one of the casualties, but it's been true for a number of years. They had gotten better at one point. Then it's slowly, unfortunately, you have a cataclysm of the baby boomers, of which Alan and I are part, coming into a certain age, and at the same time a down economy. And when you have the two of them together, it's whatever they would call a perfect storm. And unfortunately, it's hit Social Security, it's hit it very hard.
Joining us now from Texas is the Honorable Roger Schwartz. He is retired, former Social Security disability judge. He's joined this program numerous times in the past, but now that he's gone south, not figuratively, Judge, just literally, where you're now living in Texas. But it's great to have you on the program, and nice to hear your voice tonight.
Yes, thank you very much. I didn't get to hear what my two honorable attorney friends have had to say. I wonder if I could get my spiel in here, and then you can pick it apart if you wish. I'd like to take a somewhat iconoclastic view as a former active judge. I think we need a fundamental change in the whole process, and it probably would require a legislative framework to start the whole thing and to put it into regulations. The change needs to address just what is appropriate quality and quantity of legal due process for disability cases, so that we can say due process has been provided for each claimant. Right now, the legislature has provided for the right of a full-blown formal administrative hearing in accordance with the Administrative Procedure Act. And for each applicant for disability benefits, should their application for benefits be denied at the first application level.
Right. So they go to the Social Security Administrative Office, they apply, they're turned down. And again, depending on which state you're in, eventually, if they get in front of a judge, as you sat on the bench for many years, they have their shot of actually having a person see them, witness their proofs, their evidence, if you will, and also the judge gets a chance to eyeball that person. And again, this is the first time someone in the administration actually gets to see, if you will, this claimant. Now, what you're saying, Judge, is that, look, with a million case backlog, I don't want to say you're throwing up the white flag, but something needs to change now because the backlog is just insufferable. And in a word or two, Judge, and I know it's hard to do this, but what do you think the answer is going to be?
I think we have to change this right to allow automatic hearings because the backlog shows that the process itself is, I won't say it's defective, but it doesn't suit the demand for administrative process. Congress needs to take another look at the concept of due process for disability cases. We have to concentrate more on written medical record reviews with well-developed, up-to-date listing standards. We have a backlog. We have 50 years of history of how to do these cases. There's a great database to go back to, and I think we have a lot of information that we can draw on.
Well, then you can hear from the judge himself. He's basically saying, the position that he used to hold, that people should not have, quote unquote, an automatic right to appeal and get in front of a judge. That maybe we need to change the system that appeals are not automatic. In other words, Judge, you wouldn't be impeded. You're not saying take judges out of the system, but that the threshold to get in front of someone like you years ago, it would be a higher threshold.
It has to be exceptional.
All right.
They have to, if we can develop standards which are well developed and include vocational, what would be a vocational standard as well when you look at the medical evidence. And this can be done. We have 50 years of data. Doctors and ALJs and vocational experts can get together. We would have medical listings which would have automatic vocational performance limitations built in.
Okay, Judge, let me get some commentary here from both Jess and Alan. And again, keeping in mind they're claimants attorneys, they're taking these cases. And actually, I think, Alan and Jess, you guys sometimes take the case right from the start, even before it might get to the ALJ process. But I think...
No, absolutely.
Right.
But one of the problems that I have with Judge Schwartz, who I respect and I was practiced in front of for a number of years, Judge, I mean, we have 50 years of history, but the 50 years of history is not making sense. You had years and years where they had dermatologists reviewing cases. We even have recently, we've seen doctors who don't have the right specialty reviewing cases. You know yourself that until you actually saw the person in front of you, that's what made all the difference. The records don't necessarily do it. They need to have something where somebody can see them face to face. You saw that, and I'm surprised at what you're suggesting now.
The inimitable voice of Jesse. I'm not saying that it's going to be easy. I'm not saying that I've got the answers in this simple half-hour interview. I'm saying it has to be looked at. What we have to do is recognize that the emperor has new clothes. Since I retired, we have 250,000 new cases added to the backlog of 750,000 cases I had when I retired. This system is not working.
Well, no, I agree, but Judge, you've known that we've known that this was coming. We've known that the baby boom generation was going to hit a certain point, and you have that, and you have the poor economy for the last 7, almost 8 years.
But there are other things too.
We have to evolve. We have to legislate a different system. We have to look at what due process is for disability cases and recognize that the right to an automatic hearing for 1 million cases is beyond our capacity. Now, if we had billions and billions of dollars to put into this program, and if we could put 3 times the amount of judges, maybe we could give these people the hearings they want. But we don't have the money. We have the people. There's lots of people want to be ALJs, but we don't have the money to spend on it. So we have to change the system. We have to have a hearing for exceptional cases, and the cases, it would be like accepting certiorari. The ALJs would have 2 choices. They could have a summary dismissal of an exceptional case. The attorney would petition for a hearing for an exceptional case, and the ALJ would summarily dismiss, and the individual could start all over again if the initial.
And Judge, and some of this is based on the fact that, look, let's face it, when people just apply at the Social Security Administration level, they go into the Social Security office, they file a claim. We know that at best 40% of those people are going to get their disability benefits. Well, we also know that by the time it gets to a judge, historically it gets up to about 2/3. But are you aware of the fact, I think in the last Office of the Inspector General just said that even judges now are starting to really clamp down. Again, whether for better or for worse, maybe they're doing it for expediency, maybe they're getting tougher, maybe they're finding that there's some political pressure at their necks. But now even judges are starting to find approval rates somewhere in the 40s as opposed to the 60s. So in some ways, that political pressure has been brought to bear, and whether it's right or wrong for the claimant, those numbers are going down.
That's fine. But what difference does it make? You're talking about the number of cases where people are not getting their benefits. So what? The cases are still mounting up. People are not getting finality. They're not getting the answers that they want. They're waiting years.
Alan, how long do people have to? Yeah, let's say I file a claim. Okay, how long do I have to wait if I file a claim before someone says yes or no?
Well, if you're allowed at the initial or reconsideration level, we're talking 6 to 8 months. From the time you request a hearing until a hearing is scheduled now, we're waiting about 16 months. And it's getting worse. Okay. But I disagree with the idea that it's because, well, let's put it this way. The numbers show that last year, 680,000 decisions were issued. The year before, under virtually the same circumstances, 760,000 decisions were issued. The year before that, 800,000 decisions were issued. It's not just that the backlog is piling up, the Social Security Administration is slowing down. They're doing less and less decisions. The idea that you can simplify this process in some way is just a pipe dream. It's been a pipe dream for the last 30 years. I've heard it time and time again.
So is the backlog due to the fact that we're seeing district office closings? People are complaining that they're shorter hours, that there are longer lines. I've even heard of ineffective 800 numbers. Giving office of at ODAR.
No, it's not the district offices. That's not where the backlog is in this case.
Okay.
I mean, the district offices are a whole different issue.
Okay.
But what you're looking at and what you're talking about is they haven't hired anybody. But to go back to what Judge Schwartz was talking about, we have, and particularly Judge Schwartz was in Northeast PA. There is inadequate mental health care in Northeast PA. There's inadequate medical care in Northeast PA. You have to have transportation. People can't get to it. You're not, until you figure out to get everybody the health care that they deserve, and Obamacare is not doing it, the people, then you're not going to have the information. And he's talking about there's got to be a program where we can come up with numbers and vocational and meld it. They tried it. They went all the way through. And the cost of that was so tremendous, they killed it. This is 3 years ago.
Disability is never going to be easy. It's never going to be easy to make a determination as to whether or not a person is disabled. You do have to look them in the eye. You do have to see them in person. I was a staff attorney for 10 years working for an administrative law judge. The best lesson he taught me is that this is an opportunity for a citizen to come face to face with the person making the decision in their life. And that's what the disability hearing before an administrative law judge provides.
And that sounds like wonderful due process.
Tell me what's more brutal. Getting a decision in 6 months where there's closure and they say, no, sorry, you can't get disability. We looked at your records. We've had a whole panel of people review it. You can't get it. You'll have to go back and get more medical evidence. Or waiting 2 years and then maybe dying before you can get a hearing and not knowing whether or not you have disability and trying every which way to try to get to live and
Judge,
having no closure whatsoever.
Judge, if the alternative is to be turned down in 6 months with not having an opportunity to see somebody and talk to somebody and explain their problems, or to have a chance to
go
explain
back and get more evidence.
It doesn't always work that way. You have problems with the date last insured. You have problems with delays that way too. It just doesn't work that way.
We've got some phone calls and emails. Again, a reminder, 1-800-426-4625, and some emails we're going to roll in here. And I think this first question might actually be on point. Deanna from Philadelphia is up first tonight. What's your question for us, Deanna?
Well, I am 58, and I have early-stage MS. I filed for Social Security disability a year ago, and I just heard I was turned down. Since I applied, I've now developed and I've been diagnosed with severe depression. My question is, will I have to go back and reapply since the depression has happened on top of the MS?
No.
And can I get a lawyer now and have a judge hear my case?
Well, yes, you can get a lawyer now, and it's going to take a while, and it's going to take over a year.
I'm sorry? Go ahead. Say that again, Deanna.
I'm going to hang up so I can hear what you're saying better.
That's fine.
One, you don't have to file a new application because you have a new medical condition. That's not necessary at all. You do have to file a request a hearing before an administrative law judge, and unfortunately, because of the backlog that we're talking about, we are probably talking about over a year before you're going to have your day in court. Though, you have some things going for you. You are over 55 years old. There is a good chance that you will be approved ultimately. There is even a chance under certain circumstances, though it's very rare today, that somebody could look at your case and decide, this lady doesn't have to wait a year for a hearing. It's clear that she's disabled, and we're going to approve her case otherwise. But you can't count on it. You can't force it. More likely than not, you're going to have to wait for a hearing before a judge, unfortunately.
All right, we've got some calls backed up, so let's go ahead and get to those calls. Jess, you got one comment, and then we'll get to Wayne and
to go
Easton
back to the judge.
Go
The
ahead.
judge wants a final decision in 6 months. He's the most, half a million people are getting that. There's 500,000 people that never file appeals, that never go to the hearing. So it is final for them. There's only so many people that are filtering through.
Let's go to Wayne in Easton next. Wayne, hello, how are you? Go ahead,
Hello.
Wayne, you're on the air. What's your question for us? Go ahead, Wayne.
How you doing? I'm doing fine.
Good. What's your question for us, Wayne? Go ahead with your question.
Okay, my question, I did go through the process. I've been on disability now for approximately 4 years. And the first time I was denied. The second time I actually went by myself, got all my files, everything that I needed from the hospital, from my doctors, seen the judge, talked to the judge. The judge okayed it right there at the bench. He okayed it. And I actually been trying to work to get back to work, to get off it so I can actually, do better with my life, because right now I just feel it's not enough for me. But recently, February of this year, I was in a car accident. And doing all the PT, doing all the operations, I have a settlement coming.
Okay.
And my question to you is, since I'm on disability, how do I go about that settlement?
Okay, that will affect it.
The question is, what are you getting? Are you getting Social Security disability, or are you getting supplemental security income?
I'm getting disability.
They're both disability. Without being too particular, are your benefits over $800 a month or less?
Less.
Okay, we don't know. So.
No, so then you need to talk to whoever's handling your settlement, and you need to talk about structuring it so it won't impact your SSI and your medical assistance.
Okay, I'm actually doing it myself, but so I should get an attorney, you're saying?
Well, okay, you're settling your accident case by yourself?
Yes.
You need to slow down
Okay.
and talk to somebody about how this money is going to be structured and how much you're going to have to live on, because if you're just getting SSI, it's going to blow out your SSI and your medical assistance.
Well, probably would blow out his disability too, wouldn't it?
No.
No?
No, if it's Social Security disability, Social Security is an insurance program. It's not a welfare program. You're getting an insurance benefit. If he hit the lottery for $1 million, it wouldn't change the Social Security disability benefit. It would affect the SSI, which is essentially a welfare benefit.
Wayne, just want to let you know, if you need some help in getting some advice in the right direction, you need to contact our office. Our number is there on is here throughout the program tonight. You can write to us at info@lawjournaltv.com or get the number from the operator that you're talking to right now. We'll give you a number. You can call our offices this week. We'll get you pointed in the right direction. Let's go to John in Dover next. John, good evening.
Yes, hi. My comment is on the judge level. It seems that some judges award disability at about an 80% rate, and then some judges award disability at about a 15% rate. Why is there such a discrepancy of the medical records at the judge's level? And how come they have such latitude? It seems kind of unfair.
I'm going to go to the judge, the former judge, Judge Schwartz first, and then we'll give Jess and Alan a chance. Judge, what of that? Why such a great disparity across the country in the same state? I know you're chuckling. Go ahead, tell us why.
They're human beings, and they look at the record and the evidence, and they make their decisions. They're not computers, and nothing is. Every case is unique, and people have different sensitivities, and they feel different pressures, and different factors impinge on their judgments, and that's all I can tell you.
Interesting. What's been your because look, you folks know when you step into a courtroom pretty much what that judge's track record is. Come on.
The former commissioner of Social Security, Astro, used the term outliers, and there are outliers. There's a number at both ends, and that's the important thing to realize. The bulk of judges will make similar decisions most of the time. Are there some judges who are way off on one way and way off on the other? Yeah, the caller's from Dover, Delaware. There's stories about Dover, Delaware, and some of the judges there who are particularly harsh. I understand the problem. Judges have independence in their decision making. And if you take that away completely, then well, there is no way to take that away completely. I mean, that's the basic idea.
No, it's interpretation. And when you look at the records, what you're looking at can go either way. I mean, Alan and I look at a file and we can point out the problems along the way. We know where the problems are going to be, depending on the judge. Some of the judges, there are different things they look at. You know, are you doing this? How often? We have one judge, we have several of them. How often are you going out?
Right.
Have you taken a vacation? Have you done this? Have you done that? And despite the fact that federal courts have said, you don't have to be on a couch. This is not the point.
Let's go to Robert in Pocono. Robert, you're stuck in the backlog, huh?
Yes.
What? So tell us, what's your story?
Story is a disability payment purportedly from 2005 to 2007 that I won in court June 3rd of this month, and I got the fully favorable decision June 20th. And I've been waiting 5 months for a payment from the payment center for the 20-some-odd months they owe me, and they just can't get it together to pay me my check.
That's a good point. That's something we haven't covered here. Okay, so an ALJ said, yes, you get it. Now he's been waiting, a number of months. If I get a positive review, if I get a case and the judge says yes, how long do I wait?
We're getting checks almost the same day we're getting decisions.
Yeah, it depends.
Something's wrong.
Something's wrong. There could be other reasons why it's wrong. The best thing I would suggest you do is actually not call the district office, because calling them is sometimes a waste of time. Physically go into the local Social Security district office and say, what's the problem here? Is there something you're missing? Is there something you need? Because it shouldn't take 3 months, 4 months after the decision for the benefits to actually be issued. It usually doesn't take that long.
And I appreciate what Alan said. If you know where your local congressman is, walk in the door
that's
there.
good too.
Pick up the phone.
Let's take an email here.
Been there, done that.
All right, thanks. I just want to remind folks we're going to continue taking phone calls here in the studio for about 10 minutes after, so continue to call 1-800-426-4625. We'll continue to answer your phone calls. This is from T.E. in Woodbury, New Jersey, and his question is, if there is a backlog but I have an emergency, is there a way to get emergency benefits? I'm about to lose my house. Any help, guys?
There are no emergency benefits. What there are expedited hearings under 2 circumstances. If a person is about to be homeless, imminently homeless, then we can provide evidence of that fact. That can be submitted to the administrative law judge. Usually at that point it would be the chief administrative law judge who reviews it and decides whether or not it merits expedited handling. So the cases can be expedited under those circumstances. The other circumstance is a person is about to die. And then they'll expedite the hearing for a person who's about to die, though, yeah, that's great, but it doesn't really change things very
Judge,
much.
we haven't heard from you in a very long time. We haven't had a chance to connect, and we haven't had you here in the studios for a while. Hopefully that will change next year when you come back up to Pennsylvania for a little bit. But we're going to give you the last words, if you will, tonight. Sorry, I only got about 20 seconds or so. If you could just kind of wrap this into a neat little package, if that's possible.
What I want to say is I hope that the Congress, and I hope maybe this program helps the Congress to recognize that the emperor has no clothes, and they have to look at this thing and adopt a new system. This system is not working. The system is graphically illustrated by the fact that in the 6 years that I retired, the backlog has increased by 250,000 cases.
Judge, thanks so much. Unfortunately, we've got to say goodnight. I want to thank you. We'll have you back here in the studio. I want to thank Jess Leventhal and Alan Polonsky. For all of us here at the American Law Journal, thanks for joining us this Monday night. Until next week, case closed.
This week's American Law Journal has been made possible in part by Law Catalyst, legal media and marketing for lawyers. Go to lawcatalyst.com. Beatty, Sloan, and DeGenova. Decades of experience providing personal attention to those injured at work or suffering from serious injury due to medical malpractice, defective products, motor vehicle accidents, and other causes, with offices in Philadelphia and Haddonfield, New Jersey. Scheller PC. Since 1977, its mission has focused on one thing: protect the rights of individuals harmed by others' negligence or corporate misconduct, representing people injured by dangerous drugs, faulty products, and whistleblowers in False Claim Act and qui tam matters. And the Legal Intelligencer, an American lawyer media company, and the oldest daily legal newspaper in the United States.